Good afternoon, everybody. So we're here to talk about the National Association of Realtors lawsuit and what it means for the real estate industry going forward here. I think in order to understand what we're looking at going forward, we need to know where we've been. So there's two competing aspects to this. There's a Department of Justice investigation that's been going for about 20 years. And then there's the recent lawsuits that were filed 4 years ago that finally came to a head with this proposed settlement. The settlement is 108 pages and it has not been officially signed off yet. However, we are hoping that this will be signed off and will end the seller litigation. So most of us know about the copycat cases that have been filed. This would solve anything on the seller side. So the National Association of Realtors, along with one more brokerage, are the two remaining people in this. And if this gets signed off as a settlement, National Association of Realtors will be out. Originally, this was a $1.78 billion judgment against the National Association of Realtors. That could have been treble damaged to $5 billion, which means that the bond that the National Association of Realtors would have needed to post in order to appeal this decision was $500 million, basically. They took the smart financial side on this and decided a $418 million settlement paid over years instead of upfront is a better deal, along with the practice changes, which are far less than what the Department of Justice has in their settlement with the National Association of Realtors. So ultimately, it gave some guidance for how we're going to be going forward starting in July if this settlement gets approved. And quite frankly, it gave a lot of practice changes that I think were likely needed. And here's what we're going to talk about on that. The two takeaways from this settlement agreement. Number one, everybody realizes this, it's been the top topic of conversation, is that MLS can no longer post what the commissions are going to be. You can't put that in the fields. That will be starting in July, so MLS will get rid of that field if this is approved. Again, a lot of if on that. The better takeaway from this, though, is the second one. Buyer-broker agreements are going to become mandatory. You need to have a written agreement with your buyer before touring a house. Legally, I'm still interested to see how they're going to handle this with open houses, because that obviously is one of those wild cards. Off the top of my head, I'm thinking showing agreements and a no brokerage agreement probably are going to be forms that you will have at your open houses. However, I'm also hoping that the revisions committee decides that a separate form specifically for open houses makes the most sense. We will see revised documents before this gets implemented. So the buyer-broker agreements that you are now going to be required to have with buyers will be revised at a minimum to state in bold that commissions are negotiable. There is no flat standard. Like, there's literally language that they are going to put in every one of those, including your listing agreements. I think the buyer-broker agreement will also be adjusted because right now they're looking at a bunch of brokerages, different ones, and they're going to standardize this, much like they standardize the wire notice frauds or the notice for wire fraud concepts and everything like that. So your two main takeaways from that aspect: buyer-broker agreements are going to be mandatory and the commissions can no longer be put in MLS. Where we don't know what we're going to see. As part of that buyer-broker agreement aspect, you will be stating what your max commission that you will receive as a buyer's agent from any source. This becomes a bit of a gray area for me as an attorney, because what do we do when you have a negotiated agreement with your buyer for a 2% commission, but the seller, when you go under contract later on, is offering 3%? Technically, according to the way this is written in the settlement right now, you would be capped at 2%. However, they have not stated what we would be looking at for the amendment process. Would you just amend this before you go under contract? Is that buyer-broker agreement final for a period of time that you cannot amend it? We don't know. And until we see those revisions on the buyer-broker agreements and get some guidance, that could become a very thorny issue going forward. You're also going to get a lot of emails as real estate agents in this market to learn about what the new practice changes are going to be. NAR is an extremely important player going forward because they will have a seat with the mortgage industry, who is also likely going to be upping concessions to adjust some of this. Because right now, we need to figure out how a buyer is supposed to pay for their own broker if the seller's not offering it, right? We already have a cap on what those concessions are. They're likely going to have to make an adjustment. And much like previous conversations that we've had, VA is still going to be a headache. You're moving to Titanic. I don't know when it's going to change, but mortgage industry is going to have a huge part to play, and NAR has a seat at that table, given their lobbying arm. So you're going to get a lot of emails. I strongly advise sign up for any of those webinars with the Florida Realtor Organization that they do. Be prepared to be somewhat disappointed in the information you receive, but I think that's important to have the knowledge of what they're telling you, and then talk to your brokerage, because your brokers are also going to play a huge part in how you are coached on this going forward. I think that probably gives a good lead in to the real estate agent side.
Let's get me first.
You want to start?
You want me to go? Yeah. So something that I took out of what David just said, a couple things. First and foremost, this is not finalized. So this is not even been approved. If I say something wrong, David, correct me. I'm not giving legal advice. I'm just telling you what I've heard and what I know and what he just said. It's not finalized, right? So our business is still adding value to our customers, educating people, providing a service, providing our professional services for what we offer in real estate. In my opinion, the news shares and spreads a lot of misinformation, even down to the weather. I'm from New York. People see the hurricanes here in Florida, and they always show the worst spot, right? The guy wearing his umbrella, and he's standing in the middle of the storm, and I walk out my front door, and it's sunny. The sun is shining. It's not always exactly as it's positioned to you. I think that there will be some changes. The buyer brokerage agreement is something that in my 6 years of real estate, I probably have not utilized as much as I should have, but now thanks to these changes, it's actually made me feel more valuable in what I'm bringing to the table, because if someone isn't interested in signing my buyer brokerage agreement, how serious are they to buy a house? I know what I bring to the table. I know the value that I add, the experience that I have in buying and selling homes. It's what I do every day for a living. You know, most regular consumers don't buy and sell a house every single month, right? They might do it once a year, once every 3 to 5 years, depending on what they're doing. You know, maybe an investor's a little more educated. But at the end of the day, people are paying us for our experience and our knowledge and our expertise. It was positioned to me a couple weeks ago by my broker, Sandy Doherty. It's no longer about, is it a seller's market or is it a buyer's market? It's a skilled market, right? You need to work with a realtor or a real estate agent who is skilled and understands the market, understands what's occurring. St. Pete is different than Riverview. St. Pete is different than Tampa, right? We all want to collectively say Tampa Bay. They're each different areas with different needs, different inventory. And myself as a real estate agent, as a realtor and a professional, I know what the differences are. And I think it's just going to be more about us showing our value to people. You know, it's not, people have always worked without a realtor. This isn't new. Our commissions have always been negotiable. Just because we're putting it in a contract now doesn't mean any of that has changed. I think it is going to weed out some agents, and anybody who was here in 2020 when everybody thought they could just sell a house behind their Instagram. I think it's going to weed some people out, because real estate is a tricky business, and at the end of the day, your knowledge matters, your experience matters, and not everybody who holds a license can offer that. So I think building confidence in ourselves, what we bring to the table, is really going to make a difference in who's successful after these changes and who just takes it as this litigation ruined my whole career. That's up to you. That's a choice you get to make on whether or not it impacts your business. So those are my viewpoints.
Well, that was well said. Can you guys hear me? Everybody's good? Okay. It's going to be hard to follow up on that one. But
I know, I covered all the big ones.
Yeah, so I agree with her. It's going to weed out a lot of agents that are probably, not driven as we are and go after, our buyers and sellers and take care of them. So I definitely think that it's going to hold buyers accountable more so than we have seen in the past, because now they've signed an agreement where they have to follow through and they can't just leave like we know a lot of them do. I have seen pushback on it recently. I'm someone that has never used a buyer broker agreement, not once in my 5 years of real estate. And it's going to be a transition for me. So I need to get comfortable doing that. But I definitely think, we have to start practicing and getting ready for that. What's to come in July. Well, speculation says July, but we'll see what happens. But yeah, I don't think it's going to change the business much. I think the agents that are working hard every day like we do, I know how hard you work and how hard I work and you guys all, I think we're going to be just fine. I don't think it's going to affect us that much.
Do you guys think that with this commission lawsuit, you having to kind of defend the commission right now, that's going to affect any way that you work?
I can actually take a little bit of that. So we have already some states that are a great example of what this is going to look like. Washington State has been doing this for a while now. There was already before this 14 states that required buyer broker agreements. So this is not new. And we can already look at what those commissions look like in those states. So the national average for a commission is 5.48%. Washington State is 5.25%. It's not gone. It's slightly lower. So yes, you're probably going to have to go ahead and defend in your conversations with everybody what it looks like. But our commission average is still going to be right up there with the states that were not requiring buyer broker agreements. So that would be my take on it.
I think for me, sometimes wording is really important, especially when it comes to how I'm translating information in my brain. And not to correct Christine or David, I'm not defending anything. I'm explaining to you why it is that you should hire me over another real estate agent who might also be trying to get your business. I understand when agents are new and you're in the business, you just want to get business anywhere that you can. But as seasoned agents, I can tell you without that buyer brokerage agreement, you're going to get burned. You would have gotten burnt if this didn't pass when it passed. We've all been burnt. Anybody who hasn't used one in the past, we know that a buyer's agent or a buyer can cut you out of the deal essentially anytime they feel like it prior to contract. If anything, I'm expressing my value to you. There have always been discount brokerages since I've started my 6 years of real estate. There was always another agent who would do it cheaper than I would do it. And, when I first started, did I have to validate that by showing you, step by step what I do to list and sell your home? Yeah, right? Because sometimes you have to do that. There are people out there who don't value a real estate agent. They think all we do is unlock doors and tell you how many bedrooms and bathrooms are in the house. For my business, I'm not here to defend anything. I want to show you my value. I want to educate you as a buyer or seller. And then I want you to come back to me and say, you know what? I could pay a lower commission to this agent, but Mary Lee's passionate. She works hard. She's going to go above and beyond. She's going to list my largest asset in the best light because it's also her business on the line. I think if anything, the buyer brokerage agreement is protecting me and my business, and explaining that to customers just adds to my value.
I'm still amazed that in 2022, when you guys are driving to 50 different properties, you were not having them sign a buyer broker agreement. Because the amount of times that you all got burned with them going to an open house at the end of the day and just going and doing a contract there, insane. But yeah, there's a couple aspects of the buyer broker agreement that I think we should touch on, one of which is the retainer aspect. I'm interested to see how that plays out in the new buyer broker agreements, because the value that you have is much like an attorney's value. You just got to learn how to communicate that to somebody. And the fact that we've had a race to the bottom and nobody charging retainers for covering your gas that take them around to places, I'm not even expecting it to be a super high retainer, but we're going to start seeing some creativity on how that works. There are some logistic issues because it needs to be brokerages that can have escrow, right? We have to have some place to put that. So there's going to have to be some teaming up on that. I'm sure that's where we may end up heading, is more protection for the buyer's agents, because it's been needed for a while. So
Very well put. Real estate's the biggest investment and purchase you're ever going to make. So why would you not pay somebody that's going to take care of you throughout the process? So I'm not asking, to defend my commission. I think that people should be paid for their work. I wouldn't ask my client to go to work an 8-hour shift or 10-hour shift. Some days I work 15 hours. I want to get paid for that. You need to get compensated for the work that you do. And I know how hard I work. Sometimes it's 5 a.m. to midnight or 2 a.m. and then I get back up and do it all over again. So I'm not asking to, have them defend why I should get paid. I work hard and I should get compensated for it.
So last thing I want to say on that too, David had mentioned, I appreciate that you likened our work to an attorney's work. That's really nice. Thanks.
you're welcome.
Thanks. I appreciate that. I think I heard you say it at one of the meetings at our office that, and it's an attorney, you're not going to call them and they're going to immediately start doing legwork for you unless you're being compensated, right? And while I'm not an attorney, I'm not David, as wonderful as he is. I'm not him. I'm also pretty great though. But absolutely, my knowledge, my experience, and nobody scoffs at an attorney when they say, this is what it costs to work with me. I think half of the battle is us getting out of our own insecurities and out of our own way and stating, I am worth it. I have a brokerage behind me who supports me. I have 6 years of experience that supports me. I have a network of people that I've built over this time in my career that makes me advantageous to your largest asset. And there are going to be people who say, no, you're not. And I'm fine with that at this point. In my career, I've definitely built up the confidence to say, if you don't see that I'm worth it, that's okay. No hard feelings. Buy the house yourself or sell the house, because they've been doing it. For sale by owner signs have been in people's yards forever, right? So there are always going to be people who don't believe in you. They had their license 25 years ago and they know how it is. And that's fine. When if something happens, let me know. I'm still here to help. No hard feelings, but I'm not going to spin my tires in that anymore. I'm not showing you 50 homes unless I know I will be compensated for it. And I think we're the biggest obstacle in that. I too had never used a buyer brokerage agreement, and I've been implementing it now. And I've not gotten any pushback when you position it that way, that there are cheaper agents. There are. Shop them. I want you to, right? I don't want someone to work with me who doesn't think I'm valuable. That becomes a pretty negative transaction, right? It becomes a transaction at that point, and my business is based on relationships. So I want you to value me just as much as I value you as a buyer or seller that I'm growing my business with. So mutual understanding. Cool. So you think that with this commission lawsuit, it's not going to affect the buyer agent relationship with clients? It's just going to be more of the agent putting their foot down on deciding who is actually going to be an ideal client or not?
I would like to believe that there's not going to be any changes on it. I don't have a crystal ball on that. I mean, we know that there's going to be flat fee buyer agents coming up. Like it happens. And it's probably going to be a bit of a blip like it was on the listing side with the flat fee side. I don't think buyer agents are going away by any means. As an attorney, I do not want you guys going away, because every single deal that I have where there's no agents involved is a headache and a half for me, because I don't have the relationship with these people. I haven't seen the property. I'm working literally off paperwork, and they tell me, okay, this is what we want to do. And I can tell you at closing every single time something has gone wrong at that property, where somebody is either taking some out or whatnot. They haven't been coached appropriately. So it is very difficult on my end when there's no agents involved. I will also state it's very difficult when there's a bad agent involved, but we're hoping that in some of this we'll see a little bit less of that. The biggest thing is, I think it's kind of counterintuitive, but the listing agents will actually be the one vouching more for your value as a buyer agent than the buyer agents to their clients, because I think it sells itself that you need a buyer's agent. The bigger problem comes in, okay, my buyer wants to have an agent. How am I going to pay them? In that price range, that's the $300,000 to $500,000 houses. They don't have the ability, especially if they're getting a mortgage, to be able to pull that off. The person that actually will drive that conversation is going to be the listing agent. And the listing agent is going to have to show there, but by the grace of God, they're going to be a buyer's agent someday. They need to keep vouching for what the value of having a shared commission is on that part. So,
I think if anything, also, it gives us an opportunity as a buyer's agent to kind of show how knowledgeable we are, right? Like, how great are you going to look when, when you first start looking at homes, you're saying, there may be some sellers who are not compensating a buyer's agent. So this is what we're putting on the buyer's brokerage agreement to protect myself, my business, and of course, moving forward in the process. I think it gives us an opportunity to negotiate, right? It gives me an opportunity as the buyer's agent to be like, listen, I'm looking at this house on MLS. It's been on the market for 2 months. They're not offering any buyer's agent commission. I'm going to negotiate that with the seller, right? And how great do I look when I saved my buyers 2.5 or 3% on their side, right? Which was something that it was just always, I didn't really necessarily have to discuss my commissions with a buyer because it didn't necessarily apply to them. Well, now it gives me another opportunity to say, I negotiated my own commissions within this transaction for you on top of the inspection repairs or appraisal negotiations or, sale price reductions, whatever it is that's most beneficial for your buyer. I think it just gives you more of an opportunity to shine.
A lot of conversations I've been having with buyers lately is why wouldn't I just go to the listing agent and, I wouldn't have to pay out of pocket. So you're having to basically express your value to them and tell them how much you bring to the table and that you're representing them on the buyer side as the seller's agent and the buyer's agent. If they do the same transaction, you don't get that loyalty. It's more of a transaction rather than a relationship. So I think that we have to just communicate that to buyers that we are necessary throughout the transaction to protect them. And then, we just show our value throughout our work ethic, and it goes from there.
So my last question, David, is with this transition into I almost did that a few minutes ago. I passed it to you. Okay, I found it. When we're getting back into the MLS taking out the commission and where they're finding it, what is it the transfer of the third-party websites and how they're able to express if they did get the buyer's agent a commission?
okay, so here's where the settlement, as written, has I don't want to call it a loophole because that sounds nefarious, but has an avenue for third parties to share the commissions. Right now, Zillow, Realtor.com, all of them are IDX connected to the MLS. They have to break that. It won't really matter. The MLS not having that field is going to break that. But there's nothing that stops a third party. Now, whether or not it's going to be Zillow or not, there's a lot of interested parties that probably don't want it to be Zillow because they're competitors to a lot of agents. But all you would have is just a third-party website that everybody goes to after they do their listing, and they do it in MLS, and then they go set it up in another spot. I think CoStar was also mentioned recently about maybe they would be the ones that would also be taking advantage of this because they have an avenue that they can share it as well. So anybody that's a national company that can have reach over that and has basically an aggregator concept of, okay, we can see what this is and then we can contact the agents to see what commissions they're offering, I think that's going to be key. Here's where I think it gets sticky. I've already seen a couple people try to be on the seller side say, okay, we're okay with giving the listing agent this percentage. If you bring the buyer, we'll give you this percentage. And we want to say it's negotiable to the buyer's agent. You're setting back fair housing laws 60 years by doing that. Because if it is a minority that brings in that contract and you offer a different amount in that negotiation to them, we're looking at a whole bunch of claims on that aspect. So from my end as the listing agent, if I'm going to that appointment and they say that, I think what we want to tell them is it's negotiable. We want to have a value in there. And even if it's a minimum value, however you want to present it, a maximum or a minimum value that we are going to tell them that we're offering. And then we can negotiate from there. But we don't want to just say, oh, it's negotiable, and then see that something comes in and it's a minority, and then we have a fair housing issue. But truly, the settlement, the way it's written right now, is going to possibly set fair housing back quite a bit. But we haven't actually seen what the rules and guidelines and implementations of how they will stop that aspect. All we have right now is a settlement. We don't have, A, it's not even been approved, and B, we don't have the rules interpreting it for FAR. I'm hoping, expecting even, that FAR has some interpretation rules to stop that from happening. But yeah, that's definitely a concern going forward of how this is going to look, because otherwise we're already going to have listing agents that are, I hope you like your phones, because until somebody does come up with this third-party concept, you're going to be having to answer the phone once MLS takes this field away and explain what you're offering. So, and please, for the love of God, do not do the Facebook meme of the 3%. Don't do that. Yeah, and don't put that in realtor remarks either. It is a no-go for MLS, and MLS will have a rule, and it will be more than a hand slap because they just paid $418 million. They don't want to have to redo this, right? So, yeah.
And does the lack of transparency for the commission affect how either of you are going about reaching out to listings or anything that your buyers are looking at?
No, it hasn't changed any way that I do business. It's day-to-day function. I mean, it's not even past, like David said, it's, going to be July if it goes anywhere. So the conversations, people are asking questions, but nothing's changing on my day-to-day.
And truthfully, I think something to remind all of us as real estate agents is that we're the ones right now that are really talking about it, right? Like, I don't see any buyers or sellers in the room. I see real estate professionals who are here. We're the ones having a conversation about it. You bringing it up and providing transparency to a seller or to a buyer about what your services cost, I think can really only help us going forward. I don't know how many people in the room have ever had the Alta statement at the end of a transaction come out, and what's one of the biggest numbers that you see on there? Our commissions, right? And you got a buyer who's coming out of pocket, and then he realizes that you're making like double in what he's putting down on the house, right? It can sometimes, I think, make for like a weird interaction because they think that we're just taking this big chunk of money and we're making it. If I'm transparent with you now in the beginning, you're not shocked, and you're like, she was worth every penny of that 2.5% or 3% that she got. I think transparency in this business can only lead for more business for the agents who deserve it. And as an agent who had to work along other agents who frankly don't deserve it, there's nothing, right? There's nothing that digs me more than a listing agent getting 3% and they took pictures with their thumb over every single picture, right? Stop that. We're here to stop that. You're paying someone for their services. If you feel like you're not getting what you paid for, find a new real estate agent. There's a gazillion of us always at all times, right? I think if anything, the transparency is going to bring out better quality professionals. It's going to help my business because I don't want somebody feeling like they got duped at closing table. I do want the good review from realtor.com when we're done. I want the seller or buyer who says, man, I'm going to refer Mary Lee to everyone in my family. And they don't even talk about my commissions because they know I was better than the discount brokerage or the agent who can't move their thumb. Right? Thanks, David.
Exactly. It's about transparency and actually working for your commission and for your client at the end of the day. The commission is secondary, in my opinion, where you're doing your work, you love to do what you're doing, and at the end of the day, everyone benefits from it, and it's not just based on this lawsuit because it doesn't change what we've been doing. It just clears the road from all those agents that are getting licensed for themselves and for their friends and don't actually take this as a full-time job. I guess we can start doing wrap-up remarks with your closing thoughts boost morale with full-time realtors and where you see this transitioning to and what you hope will end up being, I guess, the golden star that comes from this? Because there's a lot of things that when they do hear the commission, buyers freak out because it may come out of pocket, but at the end of the day, like, it really still might not come from their side of things.
So I think for me, everybody's worried about it being, oh, is this NAR lawsuit? I think the practice changes you guys should make work for you. There's a couple of things that they had in there. A, the buyer broker agreement being signed is absolutely protection for you as an agent. B, not telling people that you are free. You never should have been doing that before, but this is actually going to make better agents out of you for you to think about what your value is in this. And last but not least, I actually almost don't want a third party coming forward with how to do this with the commissions, in the sense that I would rather have you guys continuing to have that conversation with the listing agent before you go. It's initiating a call to the listing agent so that you can have a conversation, whether, I don't care if it's about commissions or not. This is a relationship business. If you're calling the listing agent before showing a property, I can guarantee that you will probably have a much better chance of getting your buyer's offer accepted because, oh, I had a pleasant conversation with so-and-so on this when they went to go look at the property. And even better, if you don't bring up the commissions in that first conversation, but after you show it, say, hey, we're thinking about putting this in, might want to know what's going on with the commission side so I can give my buyer an idea of what's going on. You've now had 2 touches. And my wife is in marketing and she loves the number 3. So I'm sure you could come up with a third touch on that with that listing agent to make sure that the offer that you're putting in stands out among other people. So let the scary boogeyman in the room actually work for you, and don't be alarmed at what our practice changes are. Ultimately, all we've had is practice changes going forward for real estate agents. We haven't had a change to the market. It's just changing the mechanisms for how you guys will share your information.
I think there's a ton of question marks because we don't know if this is going to actually go into effect. We won't know until probably July, if that, maybe later. But I think it's positive. I don't see it as a negative thing at all. I think it's going to force us to, like David said, get those contracts in place with your buyers, which I should have been doing a long time ago, and just make them more, inept to work with me. But I appreciate the legal breakdown because I think it makes everybody understand what's going on a little bit better. But I think, nothing's going to change with my business. My primary focus is taking care of my clients. That's what it's always been. But I do want to get paid for the work that I put into it.
For my wrap up, I really think I want to put it back on us as professionals more than anything. It's, if you think that 2.5% or 3% you're making more money than you should, then I think it's time to reevaluate your business, because there are many agents out there that, if I were to sit down and break the hours that I've spent on a buyer, searching properties, sending them properties, calling the listing agent, driving them to it, opening the door, because that is a part of our business, researching comps, typing up the contract, you start to add those things in there and you're worth every part of 2.5% or 3%. If you are the agent who's like, oh my God, we get paid to do nothing, then you might be struggling. At the end of 2024, if this passes, it might really be a hard, transition for you. But if you surround yourself with people who reinforce what it is that you do and you bring to the table, you're going to, I think, find, and your customers will find, that you're worth it and that they made the right choice working with you, that you are knowledgeable, and that you stand by what you're bringing to the table, right? You might get a seller that's like, this isn't worth 2.5%. Do some self-reflecting. What can you do? What could you do differently to add value? Is there something more you can do? Or is there not? And you're literally just beating into a wall that's not listening to you because they don't find your value. I think it's going to start with us. We need to be confident in what we're working with, what I bring to the table, why I'm different than the discount brokerage. And a consumer will make their choice one way or another. And if you choose me, awesome. Let's build a relationship. Let's work together. If you don't, best of luck to you. Call me when you sell it. That's just my viewpoint.
Thank you, guys. I appreciate it.
Do we have questions? We want to do questions?
Question. So, I've heard a lot of different stories about the lawsuit, why it happened, and what led up to it, what the argument was. I'm curious to hear your opinion, just at a high level. Why this lawsuit happened? What the argument was, why it hasn't changed.
All right, so basically what sellers tried to, and they did successfully convince a jury of, was that they were paying the opposing side. So literally their concept was, instead of it being a split co-op, they were saying, I'm paying a full 6% and 3 of that's going to an adversary in my transaction. Not, I'm paying my listing agent and my listing agent is sharing that commission, which is what we know is happening. Where the lawsuit went absolutely sideways. First off, plaintiffs, especially in federal court, get to do a little bit of forum shopping. They picked a state that has really good evidence rules for plaintiffs. Second, they managed to get a class action certification, which also has a change in what our evidence rules look like for federal procedure, which then brings us to leaving a bench trial and going to a jury. Bench trial is when a judge gets to decide, and then if you get it, so you get a jury sat in. I love the general public. I don't particularly want my fate being decided by a panel of my peers at all times, right? I would rather have it be a judge that's well versed in what the law is, understands the different aspects. Really, I honestly think, given the evidence presented to the jury and what they were supposed to look at, it probably was actually the right call. Because as we talked about here, we have a lot of people that shouldn't be agents. Their evidence allowed them to bring in a lot of the recordings of people that should not be agents. And they were hearing that. And if I'm a jury and I'm hearing this and I'm being told what the jury instructions are and what antitrust collusion means, so the NAR having a hand at MLS really brings you that collusion 1 point there on that end. And I will say we're really summing up federal antitrust guidelines on a very, very high level here. But procedurally, they probably did find the right result on that end because NAR's hands were tied once it got set up for a class action. So once those the evidence rules changed, the writing was on the wall. And what NAR was going to appeal was going to be the class action certification. So the way this works is you get a judgment at the lower level, you try to appeal it, but you have to post a bond. In the meantime, you're doing settlement negotiations, and if this gets approved, that judgment is null and void, basically. So nobody's admitted guilt, nobody's been found guilty of anything like that, and it enables you to almost have a clean slate. Also, it hasn't been brought up by too many people I've noticed, but the settlement has a sunset date. It is 7 years for these practice changes. So that does matter too. That's another procedural thing. They can't just let things continue in perpetuity because the settlement has a period when it can be enforced. After 7 years, then it is officially set. And then all of those practice changes provisions are done. If something happens during that time period, the plaintiffs could come back and say, hey, we need to renew our judgment. So there's a whole nother aspect of federal court guidelines. And the way I like to explain federal court is it's like the professional league versus the state court minor leagues. Okay, so the attorneys that are at that level and that are making these arguments, they're not idiots. So I don't think NAR necessarily dropped the ball, except that they really probably should have had different rules for, or a different argument for why that shouldn't have been a certified class action.
There's still a chance this doesn't happen.
Yes, there is. There is a sneaky party called the DOJ, the Department of Justice. They've, again, I brought that up at the beginning because it's been 20 years for their aspect. They have a different settlement. And they don't particularly like the arrangement that is currently, I might have just turned off. Anyway, they don't particularly like the arrangement that is currently going on with how brokers or how everybody's paying their commissions. Let's just put it that way. They really want to break the sellers paying for the buyer side. With the way this current settlement is, it does not break that. All it does is it breaks the ability to communicate via MLS. That's basically all we're doing. the DOJ really wants to do consumer protection allegedly on it, and I'm not a member of NAR. I used to be a real estate agent. I'm not anymore, so I don't really have a dog in this fight. But from a high level, the DOJ wants buyers paying their agent, sellers paying their agent, and the settlement does not get there. Therefore, they could say, "Hey, this is a violation of the National Association of Realtors settlement with us, a separate case, and we think that this should not be approved." The judge takes that too highly. It's another story. I don't, in my experience in federal court, done plenty of trials there in the intellectual property world. I didn't really have any judge that suddenly said, "I'm not going to sign off on what the two parties that are in my case have agreed on." It needs to be for that to happen. And I'm not sure we're there, but I never had a case where the Department of Justice cared about what I was settling. So I'm also going to bring that up. Yep.
I was going to touch on that a little bit too. I heard from my eye, and I don't want to drop any names
Yeah.
because I don't know if it's this, but they were actually celebrating the fact that NAR settled because the deck was stacked against them in another court. So what I heard from my eye was that that court in Missouri, average median sales price is $208,000. 70% of the residents in that area are renters. 100% of the jurors were renters also. Did you hear any of that?
No, I did not know about that demographic aspect. So that does. So basically, they played the evidence game, and you know what? It was a smart play by them because the class for this is going to be including anybody that sold a house here. So whether or not you're a real estate agent or not, they managed to get the class for this settlement to be everybody that sold a house in the last 4 years, basically. Depending on what they're like, there's little guidelines, and once this gets approved, I'm sure you're going to see it like those mesothelioma settlement class actions. Come join it if you sold a house in this period of time. But yeah, I did not know that, and that's actually interesting, and it explains why the Illinois one was actually probably the real impetus for why NAR settled, because that one they were facing possibly up to like a $40 billion judgment against them on that one if they didn't appeal this one. So that was going to be a huge issue.
Buyer broker that I could and should have want to ask my broker again.
You're being recorded.
Right today, the additional terms any overage that the seller is willing to pay above and beyond our agreement split between buyer or
Okay, so here's our issue on that. Right today, I don't think that matters. You're fine, probably, with how those rules are. In July, they have very, very clear language in this settlement that it has to be an ascertainable amount. This goes back to my experience in federal court and doing settlements. I know that somebody from NAR during the settlement process goes, "Well, what's to stop us from saying our commission on the buyer's side is whatever the seller's willing to pay?" And the attorney for the other side goes, "I'm going to show you what's about to stop you from saying that." And they put in there, you cannot say your commission is whatever the seller is willing to pay. It has to be an ascertainable amount. So if you try to play the 3% minus whatever the seller is willing to pay, like if the seller is willing to pay, we'll just zero it out. That does not fly by the ascertainable guidelines from what I can see. We're going to have the Florida realtors step in and give us an idea of what they're willing to put as that in the rules. But to me, I'm going to take 3%, except if the seller's offering something, then we'll just take that. You don't know when the buyer's signing this agreement what the seller's offering, therefore it's not an ascertainable amount. So for now, sure, you can do it.
as a sideline to that, let's say a listing seller decided they want to put $5,000 for a contract written by X amount of time. Oftentimes it says agent's bonus, but it could say
Yeah, that's going to go towards that 3% or whatever percentage that you're putting on your buyer broker agreement because it says whatever compensation from any source. So yeah, you're going to SOL on that. And honestly, the one that I think is going to be real fun is going to be the builder side, because every one of those. So if you know your buyers are looking at builders, probably put 4% in there because builders tend to offer a higher commission to agents. So to the extent that we're not able to do things, yeah, that's it.
Amount that the seller does end up wanting to pay it, and then the buyer, and it's a buyer's concession, a seller's concession to the buyer, and then have the buyer have ultimately for.
Yes, and I think that's where we're going to end up seeing this happen for the mortgage industry. So we have Josh here. Honestly, the mortgage industry is going to lead the way in how this happens because the majority of our work is going to be in that $300,000 to $600,000 range with a loan on it, right? So Fannie and Freddie have huge pull in what it's going to look like, and this is one of the main reasons, part one of two, of why I would not stop paying my NAR dues if I was a real estate agent, even though you're not required to according to the settlement anymore. Number one, you need a seat at the table as that mortgage industry is going to be deciding what they can afford. Because whatever they decide is going to be the new concession that it's going to go up by is going to likely be what the buyer's agent percentage is going to end up being. So make friends with Josh. Make friends with Fannie and Freddie. That's where you got to be on that end. The second part brings me back to my being an intellectual property attorney from before. Any of you guys that are marketing yourselves as realtors, you need to pay your NAR dues. Or you need to get new marketing. Because there is now an industry group, National Association of Realtors, that has every incentive to enforce their trademark against people that are no longer paying their NAR dues and holding themselves out as realtors because they own that lovely trademark. It is a lucrative trademark, and they will need the money for this aspect. So there's going to be, I've been in these groups before, this is probably my 20th presentation on this. There's always like 3 or 4 people that, what stops me from paying my NAR dues? That. Because unless you want to pay however much it is to remarket yourself, and there will be people, there's already going to be, we know there's a competitive trade group that's coming up. Like, it's going to happen. But that mark realtor does play very well. And by the way, NAR has already started commercials. I was watching a baseball game the other day, and I saw a National Association of Realtors commercial, and I was like, this is hilarious because I can't get away from work even when I'm just trying. So, yeah. 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 Any other questions?
Thank you guys.